right, Mr. Pinion is allegedly signing on any moment now. Good morning, Mr. Pinion. Can you hear us?
Morning. Sorry for being late.
No problem. We're going to get started now. Let me make sure everyone can hear everyone. Mr. Sadow, you can hear me?
I can, Your Honor.
Mr. Fitzgerald, you can hear me?
Yes, Your Honor.
All right, I know you can, Mr. Pinion. And Mr. Forte, most importantly, have you been able to hear all those responses to my questions?
Yes, Judge.
Great. All right, let's go on the record then. This is 15 SC 131814, State versus Robert Fitzgerald. That was a reindictment of a 14 SC case. And back in December of 2015, Mr. Fitzgerald entered a plea in his case to a term of 5 years on probation, along with a few weekends in jail. This was a long litigated matter. It was a DUI, serious injury by vehicle, etc. Ms. McCoo, who is joining us on the call, was very seriously injured by the vehicle Mr. Fitzgerald was driving, ended up at his house. Officers went there. Some mishaps with law enforcement resulted in the plea that occurred not under Mr. Pinion's watch. So Mr. Pinion is coming in behind another lawyer who took the plea. Mr. Sadow's been in the case the whole time on the defense side. And as I understand it, Mr. Fitzgerald is seeking to have his non-reporting probation terminated because his business that he owns and operates has fallen on hard times, as have many businesses during the pandemic, and that he applied, Mr. Fitzgerald applied for some of the federal funding, but was denied because he's on probation. What I'd like to do is hear a little bit from Mr. Sadow. He may say, basically, Judge, what you just said, but he can add whatever he wants to add. I may have a few questions for Mr. Fitzgerald. And then, of course, I want to hear from Ms. McCoo. When I reached out through Ms. Nelson to Mr. Pinion to see if the state had any objection to this request. Mr. Pinion, new to the case, did what he was supposed to do, which was to reach out to Ms. McCoo, and through him, Ms. McCoo has expressed some concern. So I want to hear from Ms. McCoo as well before I decide what I'm going to do. With that, Mr. Sadat, why don't you let me know what's happening from Mr. Fitzgerald's side?
Well, Your Honor, you actually have summed it up rather succinctly. You have what would be the motion. You have a copy of the sentence. You have Exhibit B, which sets out precisely what Mr. Fitzgerald's economic and financial difficulties are during the COVID-19 pandemic. A couple of salient facts. There's a little more than 4.5 months left on probation, which means he's been on first offender probation for over 55 months. As I understand it, it's been non-reporting for almost 2.5 years. And actually, at no fault suggested, but actually under 42-8-37C, subparagraphs 1 and 2, which came into effect after Your Honor sentenced. Probation was supposed to give you an update on Mr. Fitzgerald after 3 years so that Your Honor could see whether or not any action on your part for potential early termination was possible. It's not a qualified offense, so it's not, there was no presumption. But Mr. Fitzgerald has done everything that he's supposed to do. As far as I understand, there's been no violations. I obviously realize Ms. McCoo's position here, and I realize she should have the opportunity to be heard, but here's an individual who's done everything he's supposed to do pursuant to his first offender status. There's no reason why he and his employees should be harmed under these circumstances when you're only talking about 4.5 months left. And I've told Mr. Fitzgerald that the court will probably have questions for him about his business, so I'll leave that to the court to ask whatever questions it deems appropriate.
Okay. Mr. Fitzgerald, well, let me start with Ms. Crawford, who is with the Department of Community Supervision. She does not supervise Mr. Fitzgerald. No one does right now because it's unsupervised. But I would ask Ms. Crawford to check, scribe, or whatever the system is to see if there's anything in DCS's system that suggests Mr. Fitzgerald had any issues while he was being supervised.
Judge, I already checked last night. He has no history. He has been in compliance. He has paid all his fees, and he hasn't had any violations.
Okay, and that's consistent with what Mr. Sadat represented.
That's correct.
Mr. Fitzgerald, what I really like is what I call Exhibit C. I don't have it, but I think you or Mr. Sadat ought to be able to get it to me quickly. And that would be whatever correspondence you receive from the federal government saying you can't participate in the PPP, Paycheck Protection Program, because you're on probation. That seems to be the obstacle. Your business is small, so it ought to qualify. If the only thing standing between relief for your employees is the fact that you're on probation, then we ought to engage on that. But I'm wondering if there's some kind of documentation you received that you could share with me and that I could get to Mr. Pinion just to shore that up.
Actually, when I was doing the online application, there was a question that says, are you on probation? And obviously I clicked yes, and it just stopped right there. And it said, the answer to this question must be no. Okay. And that was the end of the application process for me.
So you sought the relief and you hit the brick wall, that box that folks have to check. Are you a felon? Are you on probation? And you checked honestly, the one that indicated you were on probation, and they were done.
Correct. And then the program was done, and now they've extended it to August 8th, which is I believe, the end of this week. So The original program stopped and then they extended it.
Okay. Mr. Fitzgerald, are you able to hear me clearly, or am I hard to hear?
Now I can hear you fine. Can you hear me okay?
I can. I just got a note from someone saying, to make sure
Whoa.
Forte could hear me. Forte, are you able to hear me?
Whoa.
Judge, I'm getting some noise from somebody else's microphone and it's blocking you out.
Okay. I think Mr. Pinion was having an issue. He may rejoin us. He froze. Mr. Fitzgerald, when you were in court working through your case and ultimately entering your plea, some of the work you were involved with required you to travel. Have you changed lines of work? I reckon you spent 5 years. Are you doing something different now than you were doing before? Because you were somewhat of a globetrotter back when Mr. Sadow and Mr. Hopkins were battling for you in court.
No, nothing has changed. I work locally mostly,
Okay.
construction.
You haven't had to travel abroad, I guess, much, because I haven't had to sign anything since, looks like it was 2016 was the last time. So tell me then, how many workers is it that you who depend on the viability of your business for a paycheck?
There are 5 direct, and then there's a bunch of subcontractors over and above that.
Okay. All right. And as I understand your simple request, if you terminate my probation, judge, I don't have to check yes on that box, and thus I and my company ought to qualify for the relief, which would help it and your company get through these complicated times.
That is correct.
Okay, that makes sense. Ms. McCoo, Mr. Pinion dropped off. That doesn't mean I can't hear from you right now. He'll dial back in. He was having a little trouble with his phone. But I would like to hear from you. I know way back in December of 2015, you were frustrated. You felt there ought to have been a different outcome in this case. Ms. Rolak was not involved with the case back then, so I don't know how much was explained to you about the fact that I entered some legal rulings because of things that the law enforcement and the prosecution failed to do that made it harder for then the state to go forward with some of the more serious charges. But be that as it may, the state resolved the case the way they did. I know you were frustrated with that. I heard from you extensively at Mr. Fitzgerald's sentencing. What I'd like to do first is hear from you as to how you're doing. It's been 5 years for you as well. And so I'd like to know what you're up to, and then you should share with me what you think about this request to basically end Mr. Fitzgerald's sentence about 5 months early, not so he can go play golf, but so that he can apply for relief that would, it sounds like to me, most directly affect folks who work for him, not so much for Mr. Fitzgerald. To be clear, it would benefit him as well. It helps his company. But I'm more focused on the folks who work for him and depend on those jobs for their livelihood. So first, tell me how you've been over the last few years, Ms. McCoop.
Since the last 5 years, my health has declined. I had to have a double lung transplant, so now I'm on disability. So these last 5 years has been a journey for me.
You have friends or family who helped you through that, or you had to battle this all by yourself?
It was just me and my mom.
Okay.
I'm an only child.
Is your mother in good health?
Somewhat.
Okay. And when you say disability, are you now not able to work at all, or are you able to do some form of work?
Or I'm not able to go back into my profession. So right now I'm trying to figure out what's my next step to do.
What remind me, I don't recall what your profession was.
I was a chef.
Okay. And you cannot do that now because is it just hard to stand for extended periods, or what?
Due to a double lung transplant, I can't work in the kitchen because of the environment with the smells and the heat.
Okay. All right. Well, tell me what's on your heart and your mind.
Well, due to this motion, I feel that I don't agree with it because with the accident, I can't get my spleen back. And now due to this pandemic, I'm even more at risk right now because of my spleen being gone. So my immune system is suppressed, so I cannot be around anyone at this moment.
Okay, so you have to be extra careful.
Yes,
All right. Is your mother working?
she works, but she tries to be extra careful too because she's the only one bringing in income.
Sure. What does she do?
She's a nanny.
Okay. All right, well, that's a complicated thing to be these days as well. So
Yes.
what are you thinking about as new types of work to do when things settle down a little bit?
Well, since the accident, I actually volunteer with Mothers Against Drunk Driving, and I go and speak at this victim impact panel.
Okay, and are you able to do, how often do you do something like that?
Say that again. I'm sorry, Judge, I can't hear you.
How often do you do that?
Twice a month.
Okay, well, good for you. I think that's a great way to give back and turn some of your suffering into education for others. So Ms. McCoo, tell me how you think I ought to work through the impact on Mr. Fitzgerald's employees. I understand your position. I've understood your position from day one. This case didn't resolve in a way that probably makes a whole lot of sense to you. But the new thing on my mind is what I ought to do with the folks who are working for Mr. Fitzgerald, who might not have jobs if we don't address this issue that just came up.
I understand your position, and I understand that these employees would need a job. But from my point of view, I can't get my spleen back. My wrist is always going to have issues. So why can't I can get off my injuries in 4 months? So or in at the August. So why can't he just go on and continue to his duty his consequence for the next 4 months?
Okay. I understand that. I appreciate you sharing that. I hope you keep up doing the work with MAD, even during these pandemic times. I hope they're still doing that, maybe virtually rather than in person.
No, they're not doing it at all.
Okay. Well,
Even if it was, I wouldn't be able to do it unless it was virtual.
okay. All right. Anything else, Ms. McCoo, you want to share with me?
No, that's all, Judge.
Okay. Well, thank you for dialing in. Mr. Pinion, anything you want to add?
No, Your Honor, I wanted her to have the opportunity to be heard by the court. The defendant was sentenced. I read all the notes in the file before, and I saw that Ms. McCoo wasn't particularly satisfied with the sentence, although it was a negotiated plea. So I had a long discussion with her, and I promised her that she would have the opportunity to speak to you. And this was the sentence you gave, and she wanted it to be done until its completion. And run a new GCIC on the defendant. And I did not see anything, but I wanted to make sure of that as well. And we just asked that the sentence stay as you initially, and after looking at the facts, decided what the sentence should be.
Okay. Well, I appreciate that. My recollection, and Mr. Sadar, I think you're the only contact from back at the time, was that actually what was negotiated was straight probation. And I added the 4 weekends of jail. Is that a mistaken recollection? Or
No, that's an accurate recollection. It was straight probation. Your Honor chose to impose a number of weekends in jail as a condition of the probation.
Okay. And those were successfully served. So, Ms. McCoo, this is not a case where you are ever going to wake up one morning and feel that justice was done. I get that. That's frustrating for me. It doesn't, to your point, if none of this brings your spleen back or makes your wrist better, what I'm wrestling with right now is what is the value to our community, which we're all members, to have Mr. Fitzgerald spend another 5 months on non-reporting probation versus the value to other members of our community who work with Mr. Fitzgerald, keeping them employed so they can take care of their families and their needs. And those are the tough things to weigh because they're all important things. I appreciate that you're not going to get closure in this situation, Ms. McCoo, but there is more of a sense of closure if Mr. Fitzgerald completes his entire sentence. And you are not left feeling like here's another corner that got cut. He didn't really go to jail. Now he's going to get out of probation early, et cetera. So I am tuned to your frustration. And it was helpful for you to give me an update on how things are going. But I also see all around me businesses shutting down. We all read about the unemployment rates. And I want to be thoughtful before we take any steps that add to that situation. So I've received the information I need. It sounds like there's not documentation that Mr. Fitzgerald has because it's an online application, and he got kicked out of that once he was honest in his application that he was on probation. What I'm going to do is take this under advisement. I will issue an order today that lets everyone know what's going to happen, and we will go from there. Mr. Sadao, anything you want to add on behalf of Mr. Fitzgerald?
No, Your Honor. Thank you, sir.
All right, Mr. Payne, anything on behalf of the state?
No, Your Honor. Thank
Okay.
you.
Well, I appreciate everyone dialing in. If you were on this call just for Mr. Fitzgerald, you're free to go. We've got a bond motion following right on the heels of this, where Mr. Wright has joined us. So if you're involved with that, please stay on the line. But for the rest of you, happy Monday, happy August, and we'll see each other sometime soon. Bye-bye.
Thank you.
Judge, if you unmute your microphone, would that cause feedback in the courtroom?
Let me try it. How about that? Is that louder to anyone?
That sounds a little better.
Okay. And they may not have known, the crew that set stuff up, that my microphone was on mute up here. I'm leery of taking stuff on and off mute because it's sometimes awful feedback, but this doesn't seem to be doing that. So,
I'd like to get with them at some point and have them go through all the microphones so we can do a sound check on it and see which is the better way to do it, because sometimes you sound like you're in the bottom of a barrel. And so it helps if we could maybe get some of that echo out of there.
yeah, sometimes I feel like I'm at the bottom of the barrel, but not right now. All right, let me get this up on the screen.
With that, he's thinking it over. Yeah. Don't know.
Mr. Pinion, are you on for this one as well, or are you done?
I didn't believe that I was. I just wanted to make sure.
We've got Ms. Hall. I think this is her case, so you're welcome to stay on if you want to mute. Otherwise, I think you are good to go.
Okay. Thank you, Your Honor.
Right.
I didn't know if Miss Hall was there or not. I could not see on this phone. So thank you.
Okay, let's shift gears. The next case we've got is State versus Anthony O'Neill, which is 19 SC 172809. Mr. O'Neill is charged with a bunch of stuff. And his attorney, Mr. Wright, who's on the call, has filed a waiver of Mr. O'Neill's presence. I met Mr. O'Neill, he was in court many months ago when we had a bond hearing, this is a renewal of that. Mr. Forte, are you good to go? Are we? Great. So we're on the record. We're also live streaming this. So Mr. Wright, if there are family members of your client who want to be following the proceedings, there's a YouTube feed that they can get to through the court's website. If I'm remembering correctly, this is the case where, very coincidentally, Mr. O'Neill is found with a badly broken leg or some real serious injury right near where the car that got hijacked crashed. And what Mr. Wright was sharing with me was that it was all an unfortunate coincidence that he happened to have been injured severely near the scene of the wrecking of the hijacked car. And Ms. Hall maybe expressing some incredulity to that version of events, but also maybe saying that there's something more that connects Mr. O'Neill to the situation. And Mr. Wright waited patiently to get that something more, but maybe that something more hasn't been provided yet. And so it's time for us to propagate it. And I may be missing a piece. I'm pretty sure I'm right about Mr. O'Neill having this real bad injury consistent with being in a car wreck. And it just so happened that it was someone he knew who crashed into him or something like that. But you all will refresh my recollection, and I'll start with you, Mr. Wright, as the movement, and we'll go from there.
Your Honor, you're exactly right. We appeared before you back on, I want to say, March 18th. And at that time, the sort of the narrow issue was it was undisputed he had a compound fracture of the leg and that was bleeding profusely from that. The state's contention is that he was driving the hijacked vehicle, and the question was, is there blood in the hijacked vehicle that would be consistent with someone with a compound fracture having occurred in the vehicle? We definitely know he's outside the vehicle at a time when he's received by paramedics and taken to the hospital. The state has provided me video footage of him at the hospital, video footage of some of the witnesses at the gas station and other places. There was a video evidence link sent to me on April 22nd. Now, I don't know if we downloaded it to a computer that crashed at my office or somehow didn't download it in time, but when the link expired in May, we've been asking the state on July 5th and July 23rd to just, well, resend the link, because if there's something on that link different than the flash drive and CD, then I don't want to mischaracterize that the state's not giving me something when in fact they have it. But right now, the things I have still don't go to the question of the court's inquiry, which was, well, what do the scene photos show? Is there something that show the blood in the van and something that would be consistent with the state's theory? The state has responded by saying, well, we have some witnesses that ID him and there's some surveillance footage. But again, the state, and again, I'm not saying the state's doing anything bad. It's just they haven't, I think, received everything that they should be receiving, at least as of April and going forward. Now, that's problematic because the scheduling order wanted all discovery in by July 1st, and then motions due behind that. But at this juncture, I would say I still don't have everything. Your Honor, as the court remembers, my client, born and raised in Atlanta, has 2 children here in Atlanta. He has an address he would live at in Jonesboro, and I can give the court that address. Attended school here, the whole works. He actually works at the Ramada right there on Capitol Ave, not too far from where all this was occurring. So based on the fact that discovery is either incomplete because it's not being sent to the state, or because the discovery, it just has an absence of what the court's inquiry actually is, which is, well, is there blood in the actual van consistent with a compound fracture? We would contend, while the state thinks there's a shoe, I'll just go ahead and put it out there. The shoe is not my client's, and if the shoe don't fit, I think we'll acquit. I hate to throw that out there, but I think you'll also see my client's clothes that were gathered at Grady are also inconsistent with the description given of the assailant. So I know this isn't the guilt or innocence phase, but I think the court wanted to get an idea because my client does have a record. And as the court said, the word coincidence sort of comes up. Is there some bona fide reasons or things that can make the court feel maybe a little comfortable granting bond or under conditions to my client? We've been asking for a bond with GPS or house arrest conditions, whatever conditions the court feels are appropriate. My client has now been in custody for 283 days, which goes back to October 25th of last year. And of course, with the virus, who knows how long it'll take for this case to be able to be resolved if we do have to try it, or even evidentiary hearings to try to sort through some of this. So I don't think Your Honor actually ever ruled from March 18th denying it. I think the court has basically still held it in abeyance, wondering, okay, what should the court do? So I'm renewing it in the sense of, since I still don't have anything from the state showing blood in the van, if they have it, give it. But if they don't, then maybe that's a good reason the court can feel comfortable setting bond for my client.
Okay, couple questions, and it may be Ms. Hall's the one to answer these. But when you say, Mr. Wright, that the clothes that your client was wearing when he arrived at Grady don't match the description of the assailant, we have 2 defendants in this case. I don't know what role is ascribed to which of the 2 individuals, but if what witnesses are saying is the guy with the red Nike shirt had a gun, and the other guy wore a blue shirt, and your guy had a blue shirt, then he's not a gunman. Or were there 2 descriptions given of both assailants, and you're saying that your client's outfit didn't match either of the described assailants?
My understanding is that the assailants were both described as wearing black clothing, all black clothing. My client was actually wearing green, I think either jeans in a green top or green jeans in a top, but something that was not how we would say all black clothing. And based on how quick this is supposed to be happening and my client's supposed to be driving, I don't see where he could have been in a position to change clothes while he's involved in a chase and ultimately a crash. So that's just another evidentiary indicator that it may well not be him, or he may not be properly charged in this case.
Okay. Second question, again, maybe one for Ms. Hall. I know you're focused on this blood, which got me focused on the blood. Do we know if the nature of the accident was such that your client was ejected from the car, so the blood's going to be where he hits the ground, the curb, the wall, whatever he hit, and not in the car?
No, there's no information to indicate he was ejected from the car. He did not go through either the windshield, and there's no indication indicating somehow he was thrown from the door in any way. It's that the collision occurs, and then it's alleged my client is getting out of the vehicle, sits down on the curb, is the allegation, or at least I believe what the state will tell you their theory of the event is. So I'm not aware of anything that's consistent with an ejection.
Okay. All right. Ms. Hall, why don't you give me an update on what's happening with discovery, and then anything you want to add in response to what you heard Mr. Wright say.
Thank you, Your Honor. Good morning. Defense counsel was correct in saying, Your Honor, that I sent a link to him back in April 22nd of this year. In that email, I described to him what he was receiving, which would have been 12 different videos, which is actually what he's telling you he hasn't received, or which would be more important for him to receive. It's the scene of the accident. And I've watched all 12 of those videos, and it'll probably answer a lot of his questions, because in those videos, there are witnesses that say that's him walking down the street. He was the driver. And I explained that to defense counsel in this email that I provided. I understand that he hasn't been able to view those videos because that link did expire May the 5th. He did reach out to me, but as I told him, that is something that I downloaded, put in the file, and I'm working from home. So when I got to the office, I will resend that. I did send that this morning because I thought it was easier and faster if I reordered that from APD, because it is just a link. So I received that late on Friday. I did forward that this morning. Ms. Powell, which is, I believe, the assistant of Mr. Wright, has confirmed that they received it. Of course, it wasn't in time to watch any of it or to know any of the details that were contained on it. That is not all of the discovery, though. That would, in my opinion, would have eased Mr. Wright as far as him thinking that his client had nothing to do with this and being a pedestrian. The state is still waiting on medical records from this incident, because there were a total of 4 people that was in the vehicle that was hit head on from the vehicle that was stolen from that gas station. So we're waiting for all those medical records to come back, as well as the defendant's medical records. We also are waiting for the photos, because the photo lab is not open during this COVID pandemic period. It hasn't been open the entire time we've been home. So that's something that we won't get right now, but I don't think that that's gonna be a determining factor of this case. I think that's just something we'll be able to provide later. The GBI and the blood information that we keep referencing. When I watched the videos, I didn't see any blood, which means I needed to reach out to the investigators that investigate this case to see what they were able to collect and send off to GBI. I've been unsuccessful with getting in contact. There are 2 different lead investigators on this case, the one that worked the gas station and the one that actually worked the accident. So I haven't been able to connect with them to confirm whether they even got to see if CID was able to get blood and send it off to GBI. That is something that I'm still confirming. So I know that is something you all talked about with Ms. McCauley back in March. I wasn't a part of that original bond hearing, but I have been trying to confirm whether that exists or not. But whether it does or doesn't, I will provide it if it does. But I think it's important for defense counsel to download the link before it expires in November, to at least see, what I've seen that has me having the theory that I have on this case, because we do have witnesses that confirm that Mr. O'Neal was the driver. We have the witnesses from the gas station that says Mr. O'Neal was the person who pointed the gun at him and shot the gun in the gas station. So I think if we have time to review those videos, we wouldn't be here for a bond hearing, because I believe he is a danger to the community, seeing as though he took 2 people's, or tried to attempt to take 2 different people's car, strangers' car at a gas station, and then turned around and had a head-on collision running from the gas station in the same vehicle that he had just taken. But I think this, like I said, the bond hearing would, it would help if the defense attorney would look at those body cam videos from the scene, because there are plenty of witnesses that are actually pointing his client out. He did eventually get taken to Grady, but the witnesses stayed around because they watched this happen. So they thought it was important for them to be a part of this case. But like I said, Your Honor, we are still waiting on some of the discovery. I do understand there was a scheduling order that July 1st was the deadline for discovery. There are some things I just haven't been able to get with the COVID situation going on. And I've gotten what I could, and I forward that information, which I think is helpful in where we are in this case so far.
Okay, that was a lot of info. Thank you for that. Let me ask a few questions. So you said there are photos you're waiting on, but the photo lab, this would be Atlanta PD's photo lab, they're not processing photos, is that?
The photo, unless the investigator himself took photos and put it in his actual detective or investigator file. If CID came out and took pictures, which that happens on a lot of the cases, the photo lab is completely closed to APD. We'll still request things from them, and we'll just get an email back saying that they're closed during this time.
Okay, I guess I'm a little confused by that because being older, when I hear photo lab, I think, oh, they're developing the film and this and that. I'm pretty confident that whatever camera would have been used at the scene would have been a digital camera or someone's cell phone. And it may have been the official digital camera that the crime scene investigators used if one did respond to the scene. But I don't understand what a lab would be doing with that. That just means it's on a memory stick and it doesn't require people to be breathing on each other. So I'm not faulting you, Ms. Hall. Maybe Ms. McCauley or another supervisor could try to help the judges understand why it is that digital photos are stuck somewhere. They're not going to be subject to suppression. That's not going to slow us down in the sense Mr. Wright can't file a motion to suppress because he doesn't have a photo. But certainly they would help focus the way he's going to handle this case and process it. And so if you could just try to get a little more info as to why APD is saying we can't get you digital photos. It sounds like we're going to hear that repeatedly if their lab isn't up and running. So I guess what you need to do is try to get your voice on one of these lead investigators to understand, did a crime scene investigator show up and take photos? And maybe APD to APD, they can get, maybe
they did for sure. I know they did. I watched them on the video taking them.
Okay.
But as far as me getting them, I've received 15 emails back already saying no, they're closed. And I don't know if they're developing them as a, back in the day type of situation, or if that department that's called the photo lab is just closed during the pandemic. I don't go back and forth with them. When they tell me something's not accessible, I say, okay, and move on.
Okay.
But I'll look into it. I'll ask Ms. McCauley and see if she has any resources to get that.
Well, just if someone with the DA's office is periodically connecting with APD to talk about discovery issues, this seems like it would be an important one.
Right.
And how do you propose finding out if anything was sent to the GBI? Does that require you to connect with one of the lead investigators?
Yes, that was my main reason for trying to, because I know Mr. Wright mentioned that to me before, as well as Ms. McCauley from y'all's first bond hearing. So I've reached out to both of those investigators. I've reached out to the actual precinct. I haven't been able to connect with either of them. I mean, I don't just sit up and keep calling, but I've left several voicemails, I've sent emails, and I've reached out to the precinct themselves. But I'll just be a little more aggressive in trying to get that information because, like I said, I didn't see blood all over the van when I watched the video. So it wasn't as much as a concern to me as getting more so getting the actual evidence that I did know existed.
Okay. So,
Your Honor.
Posting on that, Mr. Wright, tell me what you think. Oh, I have one more question from Ms. Hall, and then get to Mr. Wright. Ms. Hall, are you aware of Mr. O'Neill giving a statement to law enforcement? I think you said someone talked to him at Grady. So are there statements he gave? And if so, have you given those to Mr. Wright?
Yes, Your Honor. There was no, well, as far as I know at this moment, there was no formal interview done with Mr. O'Neill, but I do know there were statements made by O'Neill. I heard a couple when I was watching the videos. But yes, those were provided in the link that I sent. So he has them now.
Okay. All right. So, Mr. Wright, I'm going to give you a chance to respond to any or all of that, but on that last question, I am anxious to get into your hands whatever might yield an evidentiary motion. You may have all sorts of motions in limine and things later on, but we are hoping in the not too distant future, it was supposed to start last week, to start having evidentiary hearings on a limited basis where people who want to be in court can come to court, and getting the defendants over here for court as well. It will start up sometime soon, and this would be a good case to move forward in that way. If there's something that is arguably subject to suppression or something else where we would need an evidentiary hearing. But I want to know if there is discovery you think exists, but you don't have, that's standing in the way of you filing motions.
Well, Your Honor, at this juncture, based on counsel's recitation of facts, I believe there must be either one-on-one show-ups that are being done at the different areas, and those are the videos she's referring to. So I do anticipate motions to suppress identifications. What I was interested in is, and I'm downloading the link right now, so I'll have that link in about 8 minutes.
That's your computer.
But is the whether there's actual, six-pack lineups that are actually done. It sounds like everything is a show up that counsel's referring to, which I'll see on videos, but not the safer, more cautious, more neutral six-person lineup kind of things. And again, correct me if I'm wrong, Ms. Hall, I just don't know yet if there were any actual lineups as opposed to just show-ups of people at the scene saying, oh, that's him.
Right, so the show-ups would have been done on the scene, but the lineups would have been done with the victims that were at the gas station, because they didn't take the defendants back there and show them up there, because the defendants went to the hospital. So
Yeah.
those would have been lineups that were done later with those two individual victims.
But are you aware whether lineups were actually done with them, or were surmising that if there is an ID by them that it's an actual lineup?
I'm assuming, because on the video that I watched, they are speaking to the victims at the gas station, and they tell them that they're going to do a lineup. They're going to create because they had just learned that the defendants were in an accident. So
Okay.
they were saying to them that we have them in custody. We're going to do a lineup so you can, pick these people out. So I'm assuming that happened. But again, since I haven't talked to the actual detectives and gotten that information, that's probably because all you have is the initial report. We don't even have the supplemental report of the second incident. We only have the whole entire write-up from one officer, and there are multiple reports in this case.
Okay. Well, Judge, and to address the court's inquiry, so I expect a series of, one motion to suppress ID.
Excuse me, Mr. Wright, can you wait just a second?
Okay.
Judge, I need just a second. I'm having a technical issue here.
Okay.
I'm ready, Judge. My power supply was about to stop.
Your Honor,
Hold on one second. Your power supply is about to die?
It was, we had a storm out here earlier and I had to unplug everything. And then I realized that the extension cord and everything I was plugged into wasn't plugged into the wall.
So it was giving you the warning that the battery was about empty and now you're back on the juice.
Yes, sir.
Great, okay. Mr. Wright, back to you.
Your Honor, so I anticipate motions to suppress ID from if, and I emphasize if they actually did lineups. And then, of course, I'll do it as to the show ups. I think that, again, Ms. Hall will find that when they do see the closing Grady, that my client checked in with white and black shoes, so that he had 2 pairs of shoes that were collected, as well as clothes, which all are not consistent with what is described as these assailants. Your Honor, I would just respectfully suggest to the court that a delay getting things as simple as photographs, reports, supplemental reports, lineups if they're done, that's a little different than a lab test or a DNA test, things of that nature. And if we had the benefit of those, we can say conclusively that we know we have a compound fracture with a lot of bleeding, but we don't have it inside that van, which was at the time really the question. And to Ms. Hall's credit, she candidly said her review of the videos does not reveal any blood that she's seeing, which would be consistent with him having a compound fracture in the van. All that being said, Judge, rather than penalize him for whatever delays are going on in the system and hold that against him as a reason to say he should not get bond or that he's a danger of committing other crimes or danger to the community, I would ask that we, with the presumption of innocence, give him the benefit of being able to give him a bond at whatever conditions the court wants to give him. He still has a rod in his leg. He has a very noticeable limp. And I believe they still want to do some therapy with physical therapy with him if he's released at Grady. But if the court wants to impose house arrest, GPS, along with whatever amount of a bond the court feels is appropriate, I think it's only fair that he not continue to simply be in custody while the agencies, law enforcement agencies, slowly get stuff or not get stuff to the state so that we can have better answers as to just what the character of the evidence against my client is. So again, he's not a flight risk. It sounds like what we're talking about is how much evidence is there in this case, and does that lead the court to feel like somehow he's a danger to the community, as the state is arguing? I would respectfully suggest that he's not, and the evidence is not there. And here we are in August, when we first started these same arguments all the way back in March. Again, I would just ask that the court at least set a bond with conditions so that he's not, again, just sitting indefinitely while we're waiting for unknown things to come in.
Okay. Ms. Rolak, is there anyone from any of the victims' families who is connecting with us today?
Not at this time, Judge. We do have a family who's Spanish speaking, who I will translate for after the hearing.
Okay, thank you. So here's what we're going to do. Mr. Wright, I appreciate some of your characterizations of what's been going on. It's frustrating to me as well that there are some things from this case file that we don't have yet, because I don't think the pandemic justifies the degree of delay it would take to get a photo lineup if one exists, or to get these photos processed. And I know Ms. Hall does her level best to try to connect with folks, but in the same way that Chief Justice has begun to say, enough is enough, we're reimposing deadlines, there are ways to safely do certain things, maybe not a jury trial, but certainly to get digital photos from person A to person B, or to call an ADA back when she leaves a message for you. I am going to set some deadlines. But there was some evidence that Ms. Hall got to you that for reasons I don't fully understand, but they are defense related and not state related. You never watched those videos. You've got them again. Ms. Hall has been pretty clear in describing what those videos show and say. And I think there's a third type of identification that's at play in this case. It sounds like it's more the spontaneous one where a witness says, "That's the guy right there who crawled out of the van and is bleeding on the street." I don't know what the words are going to be, but I want to give you a chance to see those, Mr. Wright. And then you can shoot an email to Ms. Nelson and to Ms. Hall. And if in your professional opinion, after watching those videos, you still think there is a meaningful debate or discussion to be had about who was driving the van, then I'm going to ask Ms. Hall to get the videos to me, and I'll watch it. But I want to give you a chance to watch the videos she already sent you back in April, and for whatever reason you didn't watch.
Well, Your Honor, if I can, not to interrupt, I just finished downloading. They are the same videos which I currently have. But again, I do not see, there are some witnesses being interviewed and things of that nature. I would go ahead and just ask if the court would go ahead and review them and see if the court gleans what Ms. Hall's indicating these videos glean for itself. In other words, we already have them. This is what I got on a disk and flash drive. It's not any different than what I have, meaning I thought there would be different stuff from that very first link. This is actually the same set of videos. And while, yes, there's statements of some witnesses making statements, that's, you know, the sum of it. And there's nothing on it that's showing, like I said, blood and things of that nature, which were, I thought, the narrow issue.
Okay. Well, the issue was what tied your client to the vehicle. And one way, if he was wearing shorts, might be that blood was already in the vehicle. But if he's wearing the green jeans you described, it may be that it takes a while for the blood to get places. And it's when he's sitting on the curb, the blood is flowing. I don't know, I wasn't there, but what I will do is ask Ms. Hall to identify which videos she thinks it would be helpful for me to watch. And she can figure out how best to get them to Ms. Nelson, whether there's a link or she wants to, in the next few days, get a thumb drive or something. I can get someone to swing by the DA's office to pick it up, but it sounds like we need to get to that level of granularity where I'm watching it, because you guys seem to have watched the same things and have very different perspectives on it. I will add that your client has a hold in Cobb, so whatever bond I were to set, if I were to set one, if he could make it, because it would be a meaningful bond where some money would need to be put down, he wouldn't go home anyway, he'd go to Cobb. But that's neither here nor there, because I'm not setting a bond at this juncture. I want to see these videos. But I also want to set a deadline that wouldn't be much more than a couple weeks out for the state to let us know, yes, we can get the digital photos, but here's why we can't. And yes, there were lineups, and here's when we're getting them. Because this incident occurred many months ago, and our first hearing was fewer months ago, but still a bunch of months. And these are all things that don't require a whole lot of person-to-person interaction to get into Ms. Hall's hands or an investigator from her office's hands. And I know that everything takes a little bit longer under the current circumstances, but this has been long enough, and we do need to sort out what's going to happen if anything. And mostly I'm frustrated that these investigators aren't calling Ms. Hall back, because this is a serious case. And if it needs to be a supervisor getting contacted with APD so that he or she can lean on these investigators, they need to get Ms. Hall this info so she can know what it is, and then she can get it to Mr. Wright so that if there are motions that he needs to file, he can file that. Ms. Hall, do you still think there are some videos that Mr. Wright doesn't have? In other words, the link you sent maybe isn't the link that covers the videos you've seen, or Mr. Wright's just not interpreting the videos you're watching the way you're interpreting?
I think it's the latter. I'm sitting over here a little confused because I'm just a little confused. But Your Honor, I will ask respectfully if I can have a little time, because I've reviewed all 12 of those videos, and it takes time. And we, as you know, we have court this week, and I'm preparing for those cases, so I will have to rewatch those videos and tailor those to, you know, try to point out what's important, and that's going to take some time. And we have court next week, so I just respectfully ask if I can have a little time to redo this, because I have a different opinion about what I saw in the videos than Mr. Wright is representing. And I mean, I have talked to officers. I just didn't talk to the two that I think are the most important for this case. And I mean, even with the photo labs, they're closed because of the pandemic. We can't make them open. I mean, I can ask them, why are they closed, for them to respond and say because of the pandemic. But I mean, no, I don't know if they're making their staff, you know, shortening the staff, or, you know, I don't know, but I know I have emails I'm looking at right now. It says because of the pandemic, they're not open. So, I mean, I don't think that this case hinges on those pictures, because we can see those same pictures in the videos.
No,
so
I have greater emphasis on things like photo lineups. You have told me you assume they're photo lineups because in watching the videos, you heard an officer say, well, we're going to come back to you with a photo lineup. It's those kinds of things. If there's a photo lineup that ought to be in the lead investigator's file, and that lead investigator ought to be able to get to that file and get it to you. So I'm stepping back a little bit from the photo lab, although I'm going to repeat, I don't get it, and it's frustrating that they think they can just shut that down. But I think until the judge wants to order it back open, it may well be closed. But I feel like, and you can correct me if I'm wrong, I feel like you don't have the whole case file yet. You said there's another supplemental report that should be out there because you have one from one of the investigators, not the other. Well, that's digital. That ought to be something that investigator can zap to you. But they're not calling you back. And it sounds like there could be photo lineups. And that's not closed. There's still the flow of business. So what I'm going to do is give you till the 17th. I'm just looking at the calendar here, and you do have some court tomorrow and on Thursday. And then next week, the beginning of the week, in theory, it can be busy. I don't know what's going to go forward and what's not. Get some motions. I don't know what we'll be able to do. But the rest of the week, next week, there's nothing criminal, nor at the start of the following week. So I'm going to give you till the 17th of August to get back to Ms. Nelson and Mr. Wright about where's the rest of the case file, and to have identified which videos you want me to watch. You're welcome. I appreciate it. If you say, look, video number 7, if you jump to the 3-minute mark, that's fine. But if these are 5-minute videos, watch the whole video. If they're 2-hour videos, I am going to ask you to say, well, you want to go to 1 hour and 14 minutes. But you know more about that than I do. That latter part is what I want to be able to review in connection with the bond request. The former part is your obligation, consistent with not one, but now 2 scheduling orders, to get to Mr. Wright the things he's entitled to be able to file motions. So I think we're at the point where if there are photo lineups and they don't get to Mr. Wright by the 17th, or you've got an explanation as to why that can't happen, the lead detective is real sick, okay, then we'll take a step back. But if it's just, it's pandemic, then it may be that those aren't lineups that the state's going to be able to use in this case, because we're approaching the 1-year mark on this case, and the pandemic didn't exist. Oh, I just got a message. When are you on break, Ms. Hall?
The 12th through the 19th.
Well, look at that. Okay. How about the 24th then? That's why we don't allow criminal, because you're going to be gone. Okay. I'm going to make it then
Thank you.
No problem. And hopefully you were going to tell me you were out.
I wasn't. I was just gonna try to make it happen.
You put in for leave, and the voice of reason here sent me a little text saying,
Thank you, Ms. Nelson.
yeah, send her some cookies from wherever you're going.
You're welcome.
By the 26th, we need to hear back about the case file and then which videos it is you think I ought to watch, and ideally where in the videos if they are longer videos. And then Mr. Wright, what we'll do from that, I'll jump on that then, and I'll let you know. I'll enter an order, either denying bond because it's not flight risk. It would be concerns about the safety of the community, risk of committing a felony. Then I'll also weigh in on whether I'm excluding some discovery because the state's had enough time to get to those photo lineups, and we'll just move on from there. Do you have other items you want me to get connected to that August 26th deadline? Mr.
Judge, if I'm understanding, so the court's just gonna sort of hold the status quo on the different issues until the 26th, we get more information about what the state has or doesn't have. And then at that point, the court can decide on bond, can decide on whether exclusionary rules appropriate and all that kind of stuff. So it sounds like, Judge, the 26th would be sort of the drop dead date for all the different things. I know, and I'll assist the state and make my suggestion as to which videos I think are the relevant ones. Almost, well, 4 or 5 of them are hospital videos, which wouldn't be the ones anyway. So of the 12 videos, we can narrow them down pretty quickly. Plus there's some that are at the gas station. And so point being is, I'll assist the state in that because it's in my client's best interest also to get the court reviewing the relevant footage.
Sure. And if you, Mr. Wright, in working with Ms. Hall, and I'd say, hey, these are the 2 videos, and the parties are just disagreeing on the significance of the meaning of the videos, we don't have to wait till the 26th. You can get them to me next week.
Okay.
But the 26th is building in that extra time for Ms. Hall to connect, not so much to review those videos, because your point's well taken. The hospital videos aren't the ones that we're focused on in connection with bond. The additional time is much more for Ms. Hall to have a chance to turn the heat up on these lead investigators to get to her when they ought to have gotten to her long ago, and maybe to figure out more about the crime lab piece. But I want to be clear about the significance of the 26th. If Ms. Hall reports back that the photo lab is still closed, but for APD, I'm not excluding the photos from the photo lab. She can't do anything about that. If they are of such fundamental evidentiary importance to the defense that I ought to reconsider that when they're finally produced, we can talk about that. I'm referring more that the 26th would be the more meaningful deadline. If there are things that the detectives are effectively sitting on, they ought to have gotten to Ms. Hall, but people are just hard to connect with right now. That's what that deadline is. The GBI does what the GBI does, and I'll extend that as well. And it could be that Ms. Hall reports back that it's Investigator Smith, and Investigator Smith's significant other has been really ill with COVID, and Investigator Smith hasn't left the house in the last few months. So the 26th is a day where we get that update, but it's not a day where I exclude that information. I'll react to what it is we hear, but so Ms. Hall understands that the answer is Investigator Smith is hard to get in touch with. That becomes a problem for the state and not for Mr. O'Neill. So I think that explains where we are, but I don't want to leave any piece hanging so that when Ms. Nelson's hearing from people on or before the 26th, well, wait a minute, you know, there also was the confession that he gave at the hospital that we both knew about, but we didn't talk about the judgment verdict. So is there anything else, Mr. Wright, beyond what you flagged that you feel is out there, but you don't have yet?
No, Your Honor. The only thing at this point I anticipate would just be the whole lineup motion to suppress ID issue.
And obviously, if you're surprised by something, you'll be given time. If Ms. Hall learns when these investigators finally call her back, oh yeah, the guy gave a statement, we'll process that. You'll have a chance to work through that. If Ms. Hall is surprised by something, we're all surprised by it. So we'll work through that.
And Your Honor, I want to be clear as to what I know right now we don't have, so that it's very clear. And I listed these things back in April. The 911 call, the medical records for all the people involved, the photos. I've added the 6-pack, assuming that there was one complete. And there also is a surveillance video that I know I need to receive from the detective file, which was from the gas station. We know that exists. I just don't have that yet.
It sounds like the critical next step for you, Ms. Hall, is to figure out how to connect with these detectives, because they may be able to tell you, we didn't do lineups. I know we talked about it, but we didn't do it. Great, you shoot an email to Mr. Wright, and he says score. There's another thing the state doesn't have. But until you connect with those two, you're left guessing as to what there may be. And they're educated guesses, because it sounds like in some of the body cam video, someone says, well, we'll get back to you with the lineup. Did it happen? Don't know. We need to get to the bottom of that. And the medical records, I know you've requested them, and I've heard in other settings where Mr. Wright wasn't present, the struggles that your office is encountering in getting medical records, even though those are digital as well. So we will work through those. But medical records don't present suppression issues. Mr. Wright's entitled to them. He'll get them well before trial, but that's not going to be the basis to suppress anything. It's, are there lineups, are there things his client said that I want us to prioritize? All right, I feel like we're on the same page here in terms of who needs to do what. I welcome the videos earlier than the 26th if folks get around to that, but the deadline for Ms. Hall, given what else is going on this month, would be August 26th. If we need to convene on the telephone in advance of that, just talk through something, just let Ms. Nelson know, and we can do that. Mr. Wright has obtained that waiver from Mr. O'Neill that I think applies to any additional discussion we have about this bond request. So I don't mind getting on the phone. That'll be quicker if folks don't need a little tidbit on the record like that. Mr. Wright, anything else on behalf of Mr. O'Neill?
No, Your Honor.
Ms. Hall?
Nothing else from the state, Your Honor.
Okay, thank you, everyone.
All right, thank you, Judge.
Ms. Nelson, I know we have a calendar
It's at 1:30.
at 1:30. Should I just leave this open? I guess I can stop.
No, it's